gentlemen, the Chief Justice of the great state of Alaska, the Honorable Daniel E. Winfree.
Thank you. Thank you so much. No masks this year. All right. President Stevens, Speaker Tilton, honorable members of the 33rd Alaska Legislature, guests, and all those otherwise joining to hear about Alaska's judiciary, good morning. Thank you for allowing me to be here for my final State of the Judiciary address, which I like to refer to as the last stop on the Chief Justice Winfree farewell speaking tour. As required by the Constitution, I must retire by my 70th birthday, which is February 12th. And so Monday, February 6th is my last day. A friend recently commented on the irony that I'm about to be too old to be an active justice on the Alaska Supreme Court, and judging from past elections, not old enough to be President of the United States. What a world. As I mentioned last year, Chief Justice George Boney, our second Chief Justice of the Supreme Court, appeared here in January of 1972 for the first State of the Judiciary address, designed to allow the judiciary to talk about what we're doing, allow you to meet with us, and to generate better interactions between the branches of government. I'm the 13th person and the first Alaskan born to address you as Chief Justice, and I'm delighted and honored to be here as I close out my time on the Alaska Supreme Court. Because there are so many new legislators this year, I'd like to introduce a few folks first. And then I'll talk about some of the judiciary's challenges and successes. And then I will finish by expanding a little bit on what I talked to you about last year, and that's our different roles in Alaska's contemporary democracy. So, the next Chief Justice will be Justice Peter Mawson, who was appointed by Governor Sean Parnell in 2012 and sits in Anchorage. I'll swear him in as Chief Justice as late in the day as possible on Monday, maybe just before midnight, probably. Although he told me he would zoom in his pajamas if I did that. And he will be our next Chief Justice. He is particularly pleased with you for allowing me to come do this before next week. Peter Mawson. Justice Susan Carney was appointed in 2016 by Governor Bill Walker and sits in Fairbanks. Justice Carney came to Fairbanks in 1987 for a one-year clerkship with Justice Jay Rabinowitz. As she always says, it's been a long year. Justice Carney. Justice Jennifer Henderson. Oh, I'm sorry, Justice Dario Borgeson. Well, I'm all out of my chronology here. Justice Dario Borgeson was appointed in 2020 by Governor Mike Dunleavy after a decade with the Attorney General's office. Justice Borgeson came to Alaska in 2008 to clerk for me, and he now sits in Anchorage. Justice Borgeson. Now, Justice Jennifer Henderson was appointed in 2021 by Governor Dunleavy and also sits in Anchorage. Justice Henderson came in Alaska in 2001 to clerk for Justice Warren Matthews, and here she still is. She joined us after serving on both the District Court and the Superior Court for a total of 8 years. Justice Henderson. Finally, I'd like to introduce my successor and soon-to-be newest justice on the Alaska Supreme Court, just recently appointed by Governor Dunleavy. Superior Court Judge Jude Pate Came to Alaska some 30 years ago and has been a mainstay in Sitka all these years. He will maintain his chambers here in Juneau, and he'll bring a wealth of experience to the court. My colleagues hope he joins the court as soon as possible so he can take my caseload. Jude Pate. Our administrative director, Stacy Mars, has over 20 years with the Alaska court system. She became our director in November of 2019, just before you know what. Stacy worked incredibly hard to navigate us through the pandemic and then the later cyber attack, and she speaks nationally to court administrators all across the country on a variety of topics. She's simply an inspirational leader for the court system. Stacy Mars. Our general counsel, Nancy Mead, came to Alaska in 1987 to clerk for Justice Ed Burke. She joined the court system in 2004 as our court rules attorney, and then she moved to her current position in 2011, where you see her almost all the time. Her goal is to help you understand our court system operations and how proposed legislation might affect how we do business. I hold her in extremely high regard, and I thank her for her nearly 20 years of service with the Alaska court system. Nancy Mead. As you may know, the bad news for us last year was former Deputy Director Doug Wooliver's retirement after nearly 30 years with the court system. The good news is we were able to find someone willing to come in and work temporarily to fill at least part of the void created by his departure. Let me introduce Doug Wooliver, our new acting director. I think this is his 27th appearance here in Juneau for the court system. And if I understand it correctly, some of you aren't even that old. Doug Wooliver. I'd also like to acknowledge Suzanne DiPietro, the Executive Director of the Alaska Judicial Council, for about the last decade. The council plays an extremely important role, constitutional role, in the judicial selection process, and that's one of the key reasons why our judiciary is pretty well recognized across the country. Suzanne has been a public sector attorney for over 30 years, and she has volunteered internationally to help with emerging democracies establish their judicial systems. Suzanne DiPietro. I have one more off-script introduction. I'd like you to meet a young lady from Fairbanks. Like me, she's a third-generation Fairbanksan. Her grandmother was Fairbanks' first woman mayor in the 60s. She spent over 40 years all across the state of Alaska as a healthcare professional and educator. And in July, we'll have been married 40 years. My wife, Kathleen Ringstead Winfree from Fairbanks. All right, all the fun stuff is done now. I would like to highlight a few of our successes and some of our challenges. Most notably, I'm pleased to report that we are now, and have been for about the last calendar year, really operating with all engines firing. We are at virtually the same levels of activity and productivity that we were before the pandemic, and we actually have increased some of our services along the way. So what do I mean by productivity? That seems a little odd concept to measure a court system's work. A court system's success in its mission to provide the public with fair and efficient justice in handling every matter that comes through the door obviously can't be measured the same way a for-profit company can be measured. But we can roughly apply some of those concepts and just look at the numbers. And numbers are awful, so I'm only going to give you three. But the statistics will show that things are happening. First, we track the number of total court hearings in a year. In calendar year 2022, we had about 333,000 hearings. That's almost exactly the same as we had in 2019 before the pandemic started. Breaking that down a little bit, about a third of those hearings were in felony cases. So that's about 6,000 or 7,000 more felony hearings than we had in 2019. So the numbers there are better. Looking at criminal change of pleas, when the court is asked to accept a negotiated plea agreement to end an entire case or maybe a part of a case, we held over 16,000 of them. And this is more than we had in 2018, again, before the pandemic. And the number of those in felony cases was higher than any of the last 5 years. So that means that we are in full recovery, so to speak, from the pandemic, and things are happening about the way they were before the pandemic. Now, those reflect good things, but I must acknowledge a data set that is much less satisfactory than we would like, and that is the number of pending criminal cases. It remains higher than normal as a result of the pandemic disruptions and subsequent unexpected events. This is very frustrating, given all the efforts and incremental progress we made well before the pandemic to shorten the time of disposition for criminal cases. And now the pandemic has created an even tougher challenge for us in that regard. Part of our mission is to bring every case to final resolution as fairly and as quickly as possible. Resolving criminal cases in particular provides closure for victims, settles a defendant's status, provides an ending of some kind or another for everybody involved. To further that, we have a strong policy and practice of making judges and courtrooms available whenever prosecutors and defense lawyers are ready to proceed with a plea agreement or a trial in any criminal case. So why this backlog, you ask? If you were here last year, and if you remember anything I said, you'll remember that 96 to 97% of criminal cases do not go to trial. They settle. They are either dismissed or there's a plea agreement. 2 to 3% of criminal cases go to trial. But cases that should have been resolved without trial did not get resolved during the pandemic, reportedly because the prosecutors, defense lawyers, and defendants needed real trial dates to prompt real action on their cases. Last year, after authorizing criminal trials to resume again in January, and I expressed confidence to you that the agency lawyers would get back to settling cases without trial and whittling away the backlog. The whittling has been a lot slower than I anticipated and that we would like. Some agencies have ongoing, very difficult staffing problems, particularly in specific locations across the street. And trial scheduling and trial logistics is a difficult thing. With not enough lawyers, you can't have multiple trials because one lawyer has to be in only one courtroom at a time. It's difficult. We know that the agencies are working hard to stabilize their staffing and to clear cases. And we know that with your help, with the agency lawyer pay increases in the budget, that's going to play an important part. It's encouraging, and I remain optimistic about this, but then I won't have to come back here next year and answer to you if the numbers aren't any better. That'll be then Chief Justice Mawson's problem. Just like those agencies and all of state government, we too have had terrible recruitment and retention challenges. It's across the board, we know. Many of our staff and even our judges are somewhat new to their jobs, but yet as a whole, the pace is quick. Filings are being properly processed and promptly. Proceedings are taking place in person, and expectations are high. We're hopeful that we'll continue to be able to retain professional, helpful, and motivated staff, and that the public will see our branch of government as responsive to their needs. Beyond recovering from the pandemic, which has been the big challenge, we've focused on enhancing and expanding some ways to provide additional service to all Alaskans. First, remember the budget crisis in 2015 and 16? I do. The court system at that time took the proactive step of closing our courthouses to the public on Friday afternoons. resulting in fewer work hours and a corresponding salary decrease for many of our frontline people. It didn't change the way judges did anything. We continued to work. But that saved the state $2 million a year in fiscal year 2017 and every year after that. I'm pleased that with your help in the budget this year, all of our larger courts already have switched to open Friday afternoons. That was a big goal of ours, and we thank you very much for your help. The remaining courts will be continuing to reopen on Friday afternoons incrementally as we move forward, and Alaskans can again access the court system on Friday afternoons. Thank you again for your help in making that happen. Now, since arriving in Juneau the other day, I've heard that some of you are wondering whether the Friday afternoon closures somehow contributed to the criminal case backlog. The answer is no. There's no connection. The Friday afternoon closures started July 1 of 2016, and it had no effect whatsoever on our case settlement rates. And in fact, the closures were really well received by both judges and agency lawyers because it gave them some extra hours out of the courtroom to do case prep for getting other trials ready to go and to develop whether cases should proceed. We had no abnormal backlog prior to the pandemic. The current backlog is a direct result of pandemic-related failures to resolve cases without trial in the normal course. Secondly, we have greatly expanded courtroom video technology as a direct result of previous pandemic concerns about health and safety. Our IT employees are traveling to jails and other detention facilities to install equipment so that more arraignments, status conferences, other criminal case hearings, and civil commitment hearings can take place remotely. This cuts down on security and safety risks inherent in transporting prisoners or vulnerable Alaskans on roads and inside courthouses, and it should result in significant cost savings for the Department of Public Safety as well. We're also working on creating a list of civil and criminal hearings that presumptively would always be remote with either audio or video technology. Hopefully video will be the predominant way to go. But we intend that any new process be convenient, cost-effective for everyone involved, fair to litigants, and less burdensome for everybody. I'm hopeful that by this time next year, we will have substantially more use of this technology in a variety of hearings across the state. Our increased use of video technology also will help the public observe and participate in our court proceedings. Through our court system website, we now are live streaming key hearings and trials in high public interest cases. And I know some of you have already taken a look at this. A recent trial had over 100 people watching and listening online, and I suspect that the vast majority of them would never have ventured to the courthouse, found a parking space, cleared security, and sat on those really comfortable wooden benches in the courtroom just to watch the trial. Indeed, this will allow citizens of Alaska all across the state to watch matters of great public interest that may be happening in Palmer, Juneau, Anchorage, Fairbanks. We're really proud of this. This is a great thing. People will be able to see real time what goes on in courtrooms, and they can see what it is that we do. And finally, in this area, last year I spoke about our nationally recognized Access to Justice Department that focuses on helping people who are self-represented navigate their way through the court system. We've launched a brand new program for landlords and tenants regarding evictions. With grant funding from the National Center for State Courts, and we're one of only 12 states to receive this grant on a competitive basis, we now have a designated staff member who's creating a pathway for landlords and tenants to resolve their housing disputes before even entering the courthouse doors. We'll provide information on rental assistance, financial counseling services, mediation, and legal assistance to help the parties avoid the cost and time involved in traditional eviction litigation. We think this program will mitigate the collateral damage of evictions, improves housing stability across the state, and allow judges to dedicate more time to other matters needing attention. I'd like to return now to my discussion from last year, our differing roles in maintaining a contemporary democracy. Since I was here last year, we've had a post-redistricting election for pretty much everybody in the room. We've had another election for governor. We have the brand new 33rd legislature. In 2 years, there'll be the 34th legislature. And in 4 years, there'll be a new governor. Alaska's legislatures and individual legislators come and they go. Alaska governors come and they go. Alaska's Supreme Court justices, like me, come and they go. Yet as Alaska approaches age 70, 6 years behind me, it remains vibrant and alive, despite the myriad political pendulums that we've seen over all these years. As I suggested would happen last year, democracy remains alive and well in Alaska. Now, you may be surprised to hear that I admire you. Maybe not. And I admire every other Alaskan who's ever thrown their hat in the ring for elected public office. I couldn't do what you do. It's not my makeup. Fighting political policy battles, entering the public square and debating civilly and sometimes otherwise, the heated political disputes of the moment, asking people for money to be elected to office, and engaging with the public every day to discern the political winds and act accordingly. I do sometimes enjoy watching you from a distance, although I often shake my head and wonder about the politics of the day. But I believe that each one of you has a sense of duty and that each of you acts in what you believe are in Alaska's best interests. I would hope that you would have a similar regard for us. But as I did last year, I want to contrast how you go about your business and we go about ours. The political branches control and conduct the state's day-to-day business. Generally speaking, political parties and politicians seek to influence government conduct through public policy debates and calls to action. By electing particular politicians to places of power and governing in a manner promoting particular public policy and related goals. To be successful, you must be able to express your personal and political views on a wide variety of topics, unending variety of topics. And perhaps more importantly, you must listen to your constituents' views. You seek information from many sources. You get advice from your closest political confidants. You look at opinion polls, check with your friends and neighbors, and then you decide which public policy is best, or at least which public policy is consistent with your constituents' wishes and perhaps your reelection plans. But to get things done, you may make temporary political arrangements. Who will be in the next coalition and why? Who will vote yea or nay on the next bill and why? Who will vote for a budget and what will their constituents get in return? You do all this in the public eye, well, some of it anyway. But your considerations are ever-changing political transactions of one kind or another. Now, we all generally like the concept of majority rule. How many times do we hear elections matter? But unconstrained transactional politics and majority rule have dangers that place minority rights and privileges at risk. So what constrains political transaction majority rule? Well, there is that pesky Alaska Constitution. One of my few recollections of law school classwork is a professor's description of the law as a set of riverbanks, In this context, the political branches can generally do whatever they want as long as they stay within the riverbanks, going down the river. But they can't jump over or unilaterally change the riverbanks. That, of course, raises the question, who guards the riverbanks? Enter stage left, or stage right, depending on your point of view, the judicial branch. Our most basic constitutional duty is to decide disputes that are brought through the courthouse doors. We don't go looking for things to decide. They come to us all on their own. All Alaskans have the right to bring a dispute to the courts, and we don't have the right to pick and choose which ones to consider. We consider them all. We are always mindful that our work involves some of the most important matters in people's lives: divorces, child custody disputes, criminal charges, civil commitments, guardianships, parental right terminations, personal injuries, contract disputes, you name it, we decide it. And of course, there are those few, very few really, in the relative scheme of things compared to our caseload, few occasions when we are asked and tasked to decide political disputes. Perhaps an election or a redistricting challenge. Perhaps turf war between the legislature and the governor. Citizens' challenges to legislatively enacted statutes, or perhaps challenges to citizen rights of initiative and referendum. So how do we go about that? It's completely unlike how you go about your business. A central feature of being an Alaska judge is making the conscious effort to put aside personal views and public opinion when deciding cases. We don't go asking our friends and confidants how we should rule. We don't conduct opinion polls to see how people think we should rule or how people will react to a ruling. We don't check with our friends in the legislature or the executive branch to see what they think about it. We consider only the evidence presented in the court, the relevant law, and we disregard everything else that could inappropriately influence the outcome, whether that decision affects one person, a family, a community, or everyone in Alaska. If we instead simply rule according to the swirl of public opinion or to what some of the legislative or executive branches want us to do, then the judiciary and the rule of law means nothing. Unlike in your world, there's no room for transactional analysis. A trial court judge works alone. In the Supreme Court, what I bring to the table in every case is my extremely hard work to understand the case, my analysis of the law, and my ultimate conclusion about what the correct legal answer is to this puzzle that has been presented to me. We don't talk about a case unless all of us are together in a room. And memos about the case go to every justice at the same time on those fabulous print-to-all buttons on our computers. We meet together in the conference room to discuss our individual views of a case, and we discuss those views until there's a majority consensus on its resolution. And then when we finally get it done, we issue a written decision. Everybody has access to our written explanation of what we decided and why we decided it. And those are the reasons and none other. They are set forth in our written decisions. This all comes to play as what I and everybody else refers to as the rule of law. Now, some of you are thinking, I'm sure, what a crock. Of course, politics are at play in our decisions, and we really are just a bunch of activist judges. But I believe that's because you see everything through a transactional political lens. You see a political dispute and conclude that any decision we might make on it must be political. I see a political dispute as just another legal dispute that comes into my chambers. One of the hundreds and hundreds and hundreds disputes I've seen in my time on the court. I look to the law, I look to the facts, and then I reach a legally based conclusion on how this dispute should be decided, just like I do in a divorce case, child custody case, a contract dispute, or a citizen's claims against the state. That's my judicial lens. And that's why when I watch you through my judicial lens, I often do not understand what it is you're doing and why you do it. But then I remind myself that you see things through a different lens than I do. So, when you are wondering about one of our decisions, and I'm sure you will, we have some fun ones still to come out, please make an effort to try to remember to think that we see it through a different lens than you see it when we're making our decisions. I do want to make a couple of comments about activist judge label. I've known what the practical definition of an activist judge is for years. It's the judge who rules against you. That's the activist judge. Because the losing side is certain that the judge is an activist, because the losing side is always certain that it couldn't possibly have been wrong in its interpretation of the facts or the law. And with respect to our decisions on important political disputes of the day, it seems like most people base their judgments about our decisions solely on how their internet sources characterize the result, without ever reading or caring about our written explanation of the relevant facts and the law and why we came to our decision. If they don't like the result, we're corrupt, incompetent, or even worse, radical liberal activists, radical conservative activists, you name it, that's what we are. When they like the result, we're incredibly smart, wonderful, or at least the blind pig who could find a truffle. And unfortunately, this view is easily encouraged and amplified by those who really should know better. Democracy and the rule of law depend upon an independent judiciary to make these hard calls without favor or bias. I recognize that some here don't believe in an independent judiciary, but rather believe that Alaska's judges should be handpicked and controlled by politicians so that the judges will render decisions that the politicians want. Our Constitutional Convention delegates were aware of that view. They expressly rejected it, along with rejecting the notion of elected judges. And they did so in favor of the merit selection process that we have in Alaska. The delegates wanted politics out of the judicial selection process all the way up to the governor's constitutionally authorized appointment of a judge from a list of the most qualified applicants provided by the Alaska Judicial Council. With apologies to Led Zeppelin and Stairway to Heaven, and those too young to understand the reference, the judiciary was intended to be a rock and not get rolled. Not long ago, I saw something attributed to U.S. Supreme Court Justice Clarence Thomas that really resonated with me, and it goes something like this. We should be careful about destroying our institutions simply because they don't give us what we want when we want it. I couldn't agree more than I agree with Justice Thomas in that regard. Our three branches of government have separate duties, and we have separate ways of fulfilling our duties, but we have really important common ground. We strive for fair and predictable government, equitable law enforcement, and respectful resolution of disputes. Alaska has had these linchpins of a functional government for nearly 70 years, and I remain confident it will continue to do so. The convention delegates signed the Alaska Constitution just before my 3rd birthday, about 2 miles from my house. I again note my favorite but little-known resolution that the delegates directed to Alaska's children, which I have hanging on a big poster outside my office door in the Supreme Court suite of offices in Fairbanks. We bequeath to you a state that will be glorious in her achievements, a homeland filled with opportunities for living, a land where you can worship and pray, a country where ambitions will be bright and real, and Alaska that will grow with you as you grow. We trust you. You are our future. We ask you to take tomorrow and dream. We know that you will see visions we don't see. We are certain that in capturing today for you, you can plan and build. Take our Constitution and study it. Work with it in your classrooms. Understand its meaning and the facts within it. Help others to love and appreciate it. You are Alaska's children. I am one of those children. Just a kid from Fairbanks. Teenage dream of sometime being in a position to make important decisions for the state of Alaska. And 15 years ago, to my delight and surprise, I suddenly found myself one of 5 people heading a branch of government of the state of Alaska. I have given it everything I have to give, and I have loved every minute of every day. To all of you other children of Alaska, young and old, live your lives, live your dreams, make Alaska an even better place for everybody. It's been an incredible honor to serve. It's been an incredible honor and a privilege to speak with you last year and this year. And so to all Alaskans, on behalf of the nearly 800 Alaska court system employees, farewell. Thank you. Thank you so much.
Madam Majority Leader.
Mr. President, I move and ask unanimous consent that the joint session stand in adjournment.
Without objection, this joint session is adjourned.
The House will please stand at ease.